Hi students! The previous video provides you with the understanding on what is norm, types of social norms, and the positions of legal norm. We have learned that legal norm aims to complete other social norm. According to Sudikno Mertokusumo, first, as society develops, legal norm governs interests that are not regulated by other social norms. Second, legal norm provides immediate and strict sanction. While I have to remind you that what do we mean by law as a norm is not only regulation by a certain state. Remember the definition of norm, a guide to act expressing values in society. Moving on, this video is dedicated to guide you further to identify law. Here are the topics of this video. First, what is the raison d'etre of law, or what is the reason why does law exist? Next, law and ethics. Law as solence norm, definition of law, and the meaning of law. From Sudikno Mertokusumo books, we learn that humans need to fulfill their interests. While they're working on it, they're interacting with other people. And there is the consequence. Conflict of interest may occur. As law evolves with society, wherever there is society, law emerges. Why? Because we need guidance for interaction. This depicts what Cicero says as ubi societas, ubi ius. Whenever there is society, there is a law. As law evolves with society, it portrays society development. Yet the development of law lags behind a dynamic society. Why? Because it takes time to enacting law. Can you give example of such dynamic in society where the law is not yet developed? I will give you some examples. Look at this picture. Yeah, it relates to the development of technology. Artificial intelligence, robot who can act as like a human. Can it be categorized as subject of law or not? Another thing, if you look at the picture, they all look similar. Human cloning is something that numbers of scientists believe technically possible. But is it already governed by law yet? Is there any country already promulgated law on human cloning? Next, surrogacy. In other countries, surrogacy is legal. But can you tell me how about in Indonesia? This picture shows two ladies looking at a laptop in the middle, I guess a forest. They've been called as digital nomads, people who work remotely using internet access. In Indonesia, do we have the labor regulation about it? Traveling to other planets, not for research. You may have heard before, trip to Mars is technically possible. What about the regulation about it then? Mars is getting more popular. Bitcoin. Have you ever heard that before? Well, those examples shows us that human development is so fast and it must be addressed by legal development. But some development are rather too difficult and too futuristic. And it is not easy to promulgate that. So that is why legal development lags behind society development. Now we move on to second topics of this video. Law and ethics. We already understand that legal norm contains guidance. Ethics, if you ever heard that before, ethics also contain guidance, values. What is the difference between law and ethics anyway? What is ethics then? Is it values? Is it guidance in interpersonal relation? What is ethics? Over the years, scholars have their thought on what is ethics, and it is promulgated into theories, doctrines about ethics. As you can see on this slide, from Jeremy Bentham to Stuart Mill to other scholars, they have their own thoughts when it comes to ethics. Of course, what is the relation between ethics and law? Ethics typically govern what we should do, what is the right thing to do, what is wrong thing to do. It is come from moral philosophy, contains values, principle, and purpose. So if you look at this link on hukum online, you're gonna see that it's citing to Jim Lee Asedeki. Jim Lee is a former of Constitutional Court Chief Judges. He mentioned that inciting to warrant the U.S. Supreme Court Justice, the relation between law and ethics depicts as outside and inside, or wide and narrow. What do we mean by that? Every violation to law is violation to ethics. But not every ethics violation is violation to law. Ethics are wider than the law. It can be acknowledged as a social base for law to operate. Or we could say that ethics are the oceans and law falls on it. Next, we move on to discuss about how law operates. There is this doctrine called as a law acting as das Sollen and das Sein. Das Sollen talking about what people are supposed to do, das Sein talking about what in reality people did. Law is a guidance. Its nature is abstract. It becomes real when there is action by human. That is why when it comes to promulgation of such norm, it is called as the Solon. Meanwhile, when people react to it, whether people follow it or whether people do not obey it, it is the trigger to make the law operate. This slide shows you how the Solon and Dyson can be used to examine phenomenon in society. The first picture shows that police help children to cross the street through the zebra cross sign, whereas the other picture shows you that some people just don't care about the rule. Although there is pedestrian bridge, they cross the street without using it. With all being said, law as a social norm, law is sort of like a part of ethics or values, law as a reality. What is law then? Scholars believe that defining law is important, but it is too difficult and would narrow the scope of law itself. Citing to Brian Tamanaha, in helping us to determine what is law, he defined law as a two concepts. The first is law as folk or society concept, whereas what people see as law is categorized as law. This is depicts what we Indonesians acknowledge as the meaning of law, arti hukum. Second is law as analytical concept. It is produced by social scientists, theoretical approach. It is namely definition of law. Or in Indonesia, namely definisi hukum. Going to discuss first about the law as analytical concept from social scientists. According to scholars Wiryono Projodikoro, law is a set of rules on human action to achieve public order. Mukhtar Kusuma Atmaja believes law not only includes principle norms but also institution and process in enforcing the norms into reality. So you can see the difference between Projodikoro and Kusuma Atmaja thought. If we look at the Projodikoro, it's only talk about law as an abstract norm, while Kusuma Atmaja has a more sociological approach because he includes institution and process in making law. Sudikro Kusumo believes that law is a set of rules on human action in society that can be enforced by giving sanction. Different with two previous scholars, Sudikno mentioned the elements of sanction. The scholar, the Council, gave four criteria of law. First, it is a rule regarding human behavior in social interaction. The rules are made by authorized official body. The rules are mandatory, can be enforced, and sanctions for violating these rules are strict. So he mentioned the elements of official body. He mentioned the elements of sanction. The question is, what is an authorized official body? If we use council definition, the scope of law is very narrow, only includes rules by government. It doesn't fit with law as a normative order that we discussed before. If law is a guidance for human expressing human values, it is not only talking about authorized official body, right? So we can look at other definition by other scholars. Malinowski believes that law can exist as binding obligation on fundamental matters without a definite machinery of enactment, administration, and enforcement of law, meaning that we have to leave out the bureaucracy and authoritative official body as one of the criteria because law is a binding guidance or obligation according to Malinowski. Believe what is law only rules produced by government falls under the category as positivist scholars. So it came from Austin thought. He believes that law is a command from the sovereign. Austin thought got some critics. For one, it is from Hart. He believed that law is not only produced by sovereign but also enforceable to them. Hart also mentioned that law is not only a command enforced by the sovereign, law must also be accepted by society. However, law is separated from morals. By saying that law is separated from morals, as a result, only norms made by authoritative officers acknowledged as law. Other norms contain guidance and relates to human morality came out from other types of social norms cannot be categorized as law, although they have sanctioned and imposed by society. They only be categorized as normative orders, but not law. Tamanangha asserts that law involves multiple social historical phenomena which have taken on different forms and function in different times and places, and therefore cannot be captured by a singular definition of law. He then cites to Harold Berman, who asserted three categories of concept of law. First, says both the ultimate origins of law and the ultimate sanctions of law in tradition, custom, and national character. Next, sees both the ultimate origins of law and the ultimate sanctions of law in the wills of the state. Third, emphasizes the relationship between law and moral justice. It sees both the ultimate origins of law and the ultimate sanctions of law in right reason. Tamanaha clarifies that each of these three categories of concept of law reflects a different intuitions of law. The first category sees law in terms of fundamental rules that order social life. Second, sees law as the institutionalized system that declares and enforces norms. The third posits justice and right as an integral to law. As we can see, if we use these three categories, law cannot only be defined as sovereign will, because it is also came from the society. It is a legal norm came from fundamental values in society. Law cannot also be defined outside the moral or justice values, because law posits justice and right. It is an integral part of law. Marita Manoha would like us to see that any theory of law that requires a comprehensive system of the creation, application, and adjudication of rule would exclude many versions of law, such as customary law, religious law, natural law in past and present. And he also cites to De Souza Santos, who believes that it might be us. Why should there completing and complementary forms of social ordering be designated as law as no rather as rule system, private governments, and so on? Posed in this term, this question can only be questioned by another question. Why not? In law, it is also important to notice the function of law. Okay? So according to her, there is a single functions of law to guide, conduct, and exercise social control, as it is also mentioned by Indonesian scholars. But Tamanaha believes that there are many other examples of what law does and cannot be captured by a singular functions of definition. He mentioned about how the tax regulation provides more than one function, not only to the government but also to the society. Defining law, it is not an easy task to do. Over the years, scholars have developed their thought, and nowadays we not only use positivist approach when we want to define law. A more sociological, anthropological approach to law is also important to see that there's so many normative orderings that can be categorized as law because it fulfills the three categories. And also, law has multiple function. It is not only to order. In some cases, it is give rights. It is also provides obligation to person, as already mentioned by Tamanaha in case of tax regulation. This is a list of references that I used to make this video. So please go check on to have a better understanding about the topics on these videos. This is all. See you next time.